Right. Good evening. Welcome to my contribution to this evening seminar, which is going to consider the relatively recent Supreme Court case of TUI, or TUI, and Griffiths. And I didn't know how long it was going to be, so I added on some extra cases at the end. So we'll see if we've got time to do that. Hopefully you're familiar, at least in part, with the decision, which states in broad terms that a fair trial requires that the disclosed expert evidence needs to be disputed if you want to challenge it. Well, that sounds straightforward enough. It actually targets, in principle, a common practice of allowing a more informal challenge to expert evidence. Now, with the intention of ultimately looking at the wider effects of the decision itself, I think it's necessary to have a look at the decision itself. Now, this was TUI and Griffiths was a relatively low-value package holiday injury claim. The claimant booked an all-inclusive holiday with TUI to Turkey, and he was unwell during the holiday and was admitted to hospital with acute gastroenteritis. Unsurprisingly, he issued proceeding against TUI, the all-inclusive holiday, it being responsible for the hotel where he was staying and who provided him with the food, and liability was denied. Now, the claimant relied on his own expert microbiologist, and TUI was granted permission to rely on theirs, yet failed to serve it on time and were left with no expert evidence. However, it would be fair to say that the claimant's expert evidence wasn't the best. It was pretty appalling, but it was in evidence, and Part 35 questions were raised of it, and the expert was not called to be cross-examined at trial. And it was only for the first time in closing submissions at the trial at first instance that counsel for the defendant, counsel for TUI, argued that the report was incomplete in its explanations, and that it failed expressly to discount on the balance of probabilities other possible causes of his illness, with the result that the claimant had failed to prove his case. Because the claimant, having eaten on his all-inclusive holiday every single meal in the hotel he had booked, had one meal outside, and clearly the defendants were looking to rely on the possibility of that meal being the one that caused him to become ill. Anyway, it was a conclusion that the trial judge accepted. So the claimant went to the High Court, where the central question was whether the judge had erred in rejecting the expert report in the absence of any evidence challenging or contradicting it. Now, Mr. Justice Martin Spencer, he considered whether a court is obliged to accept an expert's uncontroverted opinion, even if that opinion can properly be characterized as bare ipsi dixit, and if not, what are the circumstances in which a court is justified in rejecting such evidence? Well, let's just remind ourselves of the terminology. Ipsi dixit is Latin for he said it himself. It just means a bare assertion, so a bare ipsi dixit is tautologous. And uncontroverted simply means undisputed or undenied. So, in allowing the appeal, he confirmed the report was uncontroverted, nor was there any successful attempt to undermine its factual basis. So TUI took it to the Court of Appeal and won, with Lady Justice Asplen stating that there was no rule that an expert's report, which is uncontroverted and which complies with Part 35 CPR, cannot be impugned in submissions only. It had been proper to reject the report as insufficient to satisfy the burden of proof on causation due to its prima facie deficiencies, and as long as the expert's veracity was not challenged, then a party could reserve its criticisms of the report to closing submissions. In other words, it was not for the opposing party to make good the deficiencies in the other side's evidence, common words which we're probably all used to. But in the Court of Appeal, Lord Justice Bean, provided a powerful dissent on which the basis it went to the Supreme Court. Now, where it was said, and establishing the new rule, that under the adversarial system adopted in English civil proceedings, the judge must assess expert evidence for adequacy and persuasiveness, but it was for the parties to frame the issues and for the judge to decide on those issues, subject to the framing of those issues by the parties in their pleadings and conduct at trial. So, Lord Hodge again, making a subsequent appearance 7 years on after Laura's case, confirmed the general rule to be the parties required to challenge by cross-examination the evidence of any witness on material points that they wish to submit should not be accepted. I mean, that makes sense. If the position were otherwise, there would be unfairness to the witness, whether lay or expert, whose evidence is being impugned, whether on the basis of dishonesty, inaccuracy, or other inadequacy. So the appeal was allowed. Now, I know hitherto some parties that would keep quiet in the face of a deficient expert report, knowing that to challenge its weaknesses before trial may well be to invite the claimant relying on it to shore up their evidence, but now no longer. So this decision illustrates the ongoing tension with the issue of whether a claimant has discharged their own burden of proof, having adduced arguably very weak expert evidence, against the potential unfairness of a defendant simply seeking to challenge such expert evidence late on. Now, predictably, the court then went on to identify a whole slew of exceptions to the rule, which makes it all rather complicated. Now, it's not my intention to go through each one in turn. It's all relatively, or it should be relatively self-explanatory, but it appears now that the easiest way of proportionately challenging an expert without obtaining your own or calling the claimants to cross-examine them, which can be a risky enterprise, would be simply to try and bring an expert's evidence under one of these exceptions and then making the same arguments you would do before. So the two that leap out at me as the most likely basis for challenge are, should be highlighted. I think they're highlighted. But first, if criticism survives the clarification of well-framed Part 35 questions, which this is number 6, then it might be argued that an expert that has been given the opportunity to address it already and has failed would be vulnerable in the same way. The second one, which is number 3 here, I think again is bare ipsi dixit. Again, like was raised specifically on the facts of TUI, but on the facts of TUI, it actually wasn't found to be a bare assertion. It was inadequately reasoned, but reasoned, which is obviously strikes you as a counterintuitive basis for deciding a case. But not listed in the exceptions paragraph in the Supreme Court decisions is actually another exception which was identified, if not carved out, which should be familiar to us, in that the Supreme Court recognised that an expert report which is based upon an inaccurate or incomplete factual premise may remain at risk of being rejected at trial. So one can still undermine an expert report by challenging the evidence given to the expert by the party or other lay witness, so impugn the witness and undermine the conclusions the expert's drawn from it. For example, identifying the information that was not provided that should have been or was needed to be provided, or alternatively, in my area, which is mostly PI, identify the information that was possibly provided incorrectly as a basis for undermining the probative value of an expert report. However, this would only work if the expert's conclusions were materially drawn from that evidence. A couple of examples of this, not necessarily in practice yet, but in the sphere of PI might be if inevitably in a personal injury matter where history is provided to the medical expert by the injured party was later proved to be incorrect or inaccurate, but the report was also prepared with access to all the other documentary evidence, to objective examination for the client and to other objective sources. One might still argue that the expert report would be still viable despite what he was told. One would still expect the expert evidence to be preferred when in dispute with the lay evidence. Another example, again, in relation to personal injury or fundamental dishonesty, as the case may be, would be in low value injury claims, where it's a common defendant tactic not to obtain any engineering evidence or medical evidence themselves, but simply to highlight the history given to the expert by the claimant as being incomplete, inaccurate, or contradicted, and attack the claimant on the basis of it. So even in the absence of Part 35 questions, it may be open for the defendant to submit that by reason of a claimant giving demonstrable untruths, inconsistencies, and general unreliability, the claim could also be dismissed. So as far as I'm aware, that hasn't been tested as yet, but that line of attack in those sorts of cases or similar could appear to have survived the decision in Griffiths as coming under the exception of contrary factual evidence. I would imagine that might be subject to challenge and would only be available when the honesty had been very much put in issue from the outset. So, applying back to the facts of Griffiths, the Part 35 questions that had been put were focused on the criticism and counsel submissions, but whilst the expert report was short, whilst it could have been better and more expansively reasoned, none of the exceptions applied. Therefore, absent a proper challenge, it was not fair for the criticisms to be advanced or for the judge to accept them. Right, well, where does that leave us now in light of it? Well, the decision does have broad implications, not only for personal injury claims, but also for any civil claim where expert evidence being adduced. First, and obviously, it marks the end of the ambush of alleged deficiencies in expert evidence at trial by way of submissions, and confirms the overall importance of procedural fairness and the need to substantially challenge an expert ahead of trial and early. And so now, where a party presents an inadequately reasoned expert report, the other will have to obtain their own expert evidence and or require the disputed expert to attend for cross-examination unless it can invoke one of the exceptions. So this potentially makes the trial longer, incurs additional expense, when a party would otherwise have just taken a more passive role and allowed an inadequately reasoned expert to be the cause of his or her own downfall. Now, as one might expect, this is less likely to affect the high-value cases where both parties are likely to already have their own experts who have defined the scope of the dispute between them. But it will affect cases of modest and moderate value, and specifically, it will affect fixed cost cases, where there's always a tension between fairness and proportionality. And in these sorts of cases, expert reports are already subject to fixed disbursement fees. They're often brief, purposefully more limited in scope, and therefore often ripe for criticism for the inadequacy of their reasoning or data sets, which inevitably reflects the deliberate cost constraints on the parties. So the expansion and continued expansion of the fixed cost regime and the introduction of the intermediate track is going to ensure that these issues and battles relating to permission, extent, and proportionality are kept to the fore. I mean, there can already be a reluctance for opposing parties to challenge by way of Part 30 questions in view of the cost implications, and a concern, as noted before, that in putting questions an expert might use it, the opportunity to shore up their opinion, fill the evidential gap that's been pointed out to them. But the most direct outcome is that one of the most proportionate experts is that moving forward, Part 35 questions would have to be laser focused and ensure that there was an opportunity to respond to any and every challenge that ultimately you would wish to make. Now, practically, when an opposing party does want to challenge an expert, they can be up against the judiciary traditionally reluctant to grant the opposing expert permission on those grounds of proportionality, particularly say in the fixed recoverable cost cases. So from here on in, one might expect the Griffiths authority itself used as leverage to obtain opposing expert evidence. One might expect to see the judges more receptive to applications for permission to rely on expert evidence where it might have been previously refused. And it might indeed be more difficult to resist an application putting questions to a party who's already relying on expert evidence. But the most significant, or the real thin end of the wedge, which is being predicted by these essentially introducing Part 35 questions as the only proportionate means of challenging even inadequately reasoned expert evidence, is that there is a concern that the scope of those questions is going to change. Now, under CPO 35.62c, as we can see, that the intention is that those questions are put for the purpose only of clarification of the report. But if it stands as the only permitted or proportionate method of challenging an inadequately reasoned report, what we are seeing, what we're likely to continue to see, is a much more robust cross-examination style approach to Part 35 questions to experts. But in any event, this is not an area in which any party who faces an expert can afford to ignore. Holiday sickness claims and any other claims, indeed, are likely to be shorn of one common defence, which is that identifiable alternative causes or explanations have not been specifically considered and excluded. But ultimately, the most likely response that responding parties are going to work exceptionally hard to try and come in under one of those exceptions. And that's where we're likely to see the battleground of future arguments. We're probably likely to see that in early attempts to get expert evidence excluded, or early attempts to identify that an exception will apply. Right, I'm minded of the time. I wanted to just go to this one in the time to stuff. I appreciate this is clearly not an English case. This is New York State in the Surrogates Court, Saratoga County, in the matter of Weber. There are a number of other 2024 cases related to the use of expert evidence which are of interest, but I wanted to finish with this one because it relates back to what I've just been talking about in TUI Griffiths in a way, but it really has the most substantive comments on an expert's use of artificial intelligence in his expert report. The claimant was a beneficiary under an estate alleging that an administrator had failed to obtain a reasonable value for the property sold and caused him loss. And the claimant's expert was thoroughly rejected by the judge in these words. Based on the uncontroverted evidence, the court finds that the expert's calculations, and specifically those with regards to damages, are inherently unreliable, based on speculation, hypothetical market performance, and are unsupported or outright contradicted by the facts in the record. And why that was, is they were prepared using AI. And the fact of the matter is this expert said himself, in evidence, everybody does it. This is an industry standard. Now, we're looking back at the how to challenge expert evidence, or indeed ensure one can rely on it in respect of TUI. It is going to be increasing the case that we might get questions as there's increased use of AI by experts in their understanding of the role of how that artificial intelligence compiled and used that data. Otherwise, they are leaving themselves open to attack. And the expert in this case, admittedly, relied wholly on Microsoft Copilot. I'm not familiar with it, but some of you may be, in order to check his figures. And in the end, the figures weren't quite different. The task it was set, he was trying to identify what was the likely increase in value after 16 years of £250,000 invested in a Vanguard fund. And all of the answers given ranged from about $945,000 to about $952,000, which, given the scope of that task, isn't a hugely wide range. However, what the judge took issue with is that the expert himself could not explain the difference. He was simply relying on the artificial intelligence itself. He also raised very critically the difference between generative and assistive AI. Some of you might have come across generative AI because it appears, and I haven't come across this myself, except anecdotally, is that a lot of litigant persons are turning to AI to generate their legal arguments for them. And generative AIs, well, they make up cases. They can make up cases, they can make up judges, and they don't check. So, a rather enterprising judge in this case, when dismissing the evidence, actually decided to ask it. He asked the AI itself, "Are you can you be used authoritatively in a court of law? It said no. You should use an expert to check. But anyway, when we're looking at potential exclusions from the rule of TUI and Griffiths and the increasing use in complicated, especially data-driven reports, certainly in very few experts that I know have been able to grapple with in a way that they can under cross-examination or when faced with direct questions, how artificial intelligence does use those figures. So it's something to be aware of, both in the reports that you may be obtaining for your own clients and when you want to attack them in others. And obviously we're clearly going to see more and more of this going into the future. Right, as I said, there are a couple of other cases there, but you can look over those in your own time. The last one is just the formal procedure in relation to expert evidence. It's specifically for intermediate catch track CPR 28.14.3. Any expert report shall not exceed 20 pages. You're expected to have a relatively limited remit, but the Association of Expert Witnesses are committed to making that the case in all expert reports. That obviously doesn't include tables and the like, and so there are missives going out for all expert evidence to try and put a 20-page cap moving forward on expert reports. Anyway, I think I'll conclude it there. I can see hungry faces in front of me. If there are any questions, particularly about some of the cases that may have been mentioned in the slides, but I haven't gone through, please come and find me otherwise. But thank you very much. Hope you can go and enjoy a drink.